SJC-10400, Cumis Insurance versus BJ Wholesale Club.
Good morning, Mr. Panagopoulos.
Good morning, Your Honors. May it please the Court, Dino Panagopoulos along with Alan David and Joseph Nealon for the appellants, which consists largely of not-for-profit, federally and state-chartered federal credit unions. There are several issues on this appeal, Your Honors. The first issue is whether or not the Court erred in dismissing counts 1 and 2 of plaintiff's amended complaint, which alleged breach of contract against BJ's and Fifth Third based on the third-party beneficiary theory, where the court was required to accept the allegations made by the plaintiffs as true.
Can I ask you which contracts we're talking about here? Are we talking about two separate contracts?
Your Honor, what we're talking about is a very complicated contractual relationship that involves multiple parties. We're talking about contracts between Visa and MasterCard and Fifth Third Bank. We're talking.
So that's one contract.
There's
Visa,
two-
MasterCard, well, two contracts.
there's
One with
two
Visa,
contracts
one with
there.
MasterCard, both with Fifth Third Bank.
And there's a contract between BJ's Wholesale and Fifth Third Bank.
Okay? Those are the
And-
two contracts?
And those contracts all incorporate the Visa regulations and guidelines.
Do the visa regulations themselves include any language about these, who they are intended? I understand the testimony of the person whose name begins with P, but
Mr. LaPaglia.
there's a P in there. Okay. But what about the, do the regulations themselves incorporate some language about these are intended to benefit only X, Y, or Z, or anything like that?
The regulations themselves do not incorporate that type of language, but they're clearly intended to benefit issuers. The only way the system can work
No,
as a
I
whole.
understand that. It was just a factual issue. So the language that Judge Quinlan's relying on is only in the contract between Visa and
That's
Fifth
only in the
Third?
contract between BJ's and Fifth Third. That is not in the contract between Fifth Third and Visa or MasterCard.
All right. And you say that the BJ's and Fifth Third Bank contract incorporated the Visa guidelines
And also...
and the MasterCard guidelines?
Right.
Now, what do you say about MasterCard apparently says it has the sole right to enforce the regulations, and Visa says the regulations confer no rights to any third party? I assume that's part of the regulations themselves.
Well, Your Honor, I don't believe that with respect to this case that the Visa guidelines say that. In fact, what we have here is that Visa has the right to try to find parties and go after parties, but the regulations themselves with respect to Visa and MasterCard do not say that third parties cannot sue. In a very similar case in the Third Circuit, the Sovereign case, the court looked at those issues specifically and said that even though there's a very specific enforcement mechanism that deals with how Visa and MasterCard deal with violations, that the regulations do not indicate that it's the exclusive mechanism.
Is that case square on point here? Are we talking about the very same contracts?
We're talking about the very same contract, the very same breach. In fact,
And the
The
very
same-
same regulations?
same
very
regulation.
same regulations. And in fact, at the argument below, where that case stood procedurally is that the District Court of Middle District of Pennsylvania had dismissed that case and hadn't really didn't think the LaPaglia memo was as important. And Fifth Third below said, look, we're involved in all these cases. Here's a very important case. It's right on point. Same breach, same issues, and the judge said, no. Well, the Third Circuit looked at the issues in detail, went through everything in detail, and decided that the LaPaglia memo did create an issue of fact at a minimum as to whether or not the plaintiffs in that case, which were issuing entities just like our clients, were intended third-party beneficiaries of the Visa MasterCard contracts that are at issue.
So, counsel, when the judge said, in this case, the parties expressly stated in the contract at issue their intent to preclude any third-party beneficiary claims, your position is she was just wrong.
Our position is that even though the contract between BJ's and Fifth Third said that you have to consider the contract as a whole. And the contract also says that if there's any provision that conflicts with the Visa and MasterCard regulations, then those regulations will apply. And that when you look at the way the system works as a whole, the only way the system can work, because my clients could not contract individually with each and every one of the merchants out there. There were thousands and thousands of them, if not millions. And the only way the system works is if the parties can rely on the Visa and MasterCard system.
Was there any evidence that the credit cards were issued with these contracts in mind?
Well, Your Honor, the credit cards have to be issued with the contracts in mind because the Visa and MasterCard regulations are issued to the issuing institutions, and they're told that these are the rules
No,
that
but
will
when they
apply.
issued, when these credit unions issued credit cards to the credit holders, are they issued with these contracts in mind in any way?
That's what we alleged. And remember, this,
Oh, I said, is there any evidence?
well, this was dismissed on a motion to dismiss.
And you
And
allege
so-
that the credit cards were issued with these contracts in mind?
We alleged that we were the intended third-party beneficiaries of these contracts.
Now, what does the First Circuit obviously comes to a different position than the Third Circuit.
Well, but the First Circuit relied on the district court case in Sovereign, which has been
Okay.
reversed, and it also relied on this case below,
Right.
which hopefully will be reversed.
Now, is it your position that your clients simply have no remedy? The Visa and MasterCard operating guidelines afford no remedy within that structure for you?
Right. There's no effective remedy, and
Well,
Visa...
effective remedy. Does that mean there's a remedy, but it's not a good one, not a great one?
Both Visa and MasterCard testified in their depositions that the remedy that they had in place was ineffective. That they actually changed the process after this breach because they realized that the issuers were not being effectively compensated.
What is the remedy that they had in place?
The remedy is that Visa and MasterCard, for example, I believe fined BJ's and Fifth Third.
FINED, fine, that kind of fine. Yeah,
Exactly.
okay.
And that didn't go to the issuers. And in addition, there were compliance cases that could be filed, but the process was so convoluted that it wasn't effective. It didn't work. A very small percentage of issuers that were affected actually filed claims, and if I remember the statistics correctly, only 28 to 30% of those were able to get any relief whatsoever. And that's a tiny fraction when you consider that potentially 9.1 million cards were compromised in this breach, and that our clients alone suffered several $1 million worth of damages. What Visa and MasterCard said certainly rings true. There is no effective remedy. Without us being able to file these claims and go after BJ's and Fifth Third for failing to do what they promised they would do, and that we're the beneficiaries of that promise, without the ability to do that, we're left holding the bag for something that BJ's and Fifth Third did.
On your tort claims, do any of the defendants owe these plaintiffs any duty?
Sure, Your Honor. We believe that under the Danka versus Taunton Savings Bank line of cases, that they certainly owe us a duty because, again, they knew that we would be relying on them to comply with the regulations. That's how the whole system works. And by entering into these...
But you bought insurance against for the times when they didn't.
Well, that, I believe, is irrelevant as to the issue of whether we were entitled to rely on the fact that they would comply. We entered into a system that we would hope people would comply with. And generally, if you look at the statistics in general, the system does work. There's, I believe, 4 cents of fraud per every $100 that's charged. So the system in general works. But when it doesn't work, we're left with issuers holding the bag for something they had nothing to do with.
And that is because essentially the system in which they operated didn't give them an effective remedy.
Right.
I mean, presumably it could have.
Well, it could have, but it didn't, and the system they operated under didn't prohibit them from filing these claims against the parties that wound up breaching their contracts and their duties against them.
I'm sorry. With respect to the BJ's Wholesale and Fifth Third contract, you admit that there's language in there that says this is not intended to give anybody, any third party, any benefits. Your position is that simply is overridden by the regulations which are also incorporated?
Right.
But they don't specifically say that third parties do have a benefit.
But what they do is they require compliance, and in addition, those regs were implemented, and people were given notice in 1993 that they were implemented in that LaPaglia memo in order to benefit issuers. So issuers were told in 1993, look, we're changing these rules. We're making sure that they are in place to benefit the system and issuers. Issuers
That
are
memo
specifically mentioned.
didn't say everybody on notice now, third-party beneficiary claims can be brought. Didn't say that.
Well, it didn't say third-party beneficiary claims can be brought. It did say, though, we're doing this for you, issuers.
And issuers.
Issuers are the financial institutions that issue credit cards. There are
So
clients.
but did it say issuers will now have a right to bring independent actions so that, this remedy is out there for you all?
No, it didn't say that. I don't believe that it's necessary for them to say that, because all they had to say is, look, from now on you can't store data after the transaction is approved, and we're doing this because of the risk of fraud and because we want to benefit the system and issuers who are mentioned specifically. And Visa and MasterCard both testified in deposition that the change was intended to benefit issuers.
That deposition was in this case?
Depositions in this case of both Visa and MasterCard, both corporate representatives testified that that change was intended to benefit issuers, that was one of the universe of entities that change was intended to benefit.
Now, if you prevail in this case and another case comes about where there's explicit contractual language that says we wish there to be no third-party beneficiaries, if you win, doesn't that negate the possibility of getting a motion to dismiss to prevail in those cases? I mean, aren't we always going to have to hear evidence as to whether there exists some other circumstances that may negate what appears to be the express intent of the parties?
No, if you have the entire contract before you, and there's no question that you have the entire contract before you and the entire relationship before you, you can look at that and make a decision. The problem is that here we didn't have that.
What didn't you have
Well,
that
we
could
certainly
have been
didn't.
available?
We certainly didn't have the LaPaglia memo.
Right,
that was
so you
issued.
need discovery to gather memoranda that discuss the purpose of the regulations that are incorporated by reference into the contract?
Well, and we also had the regulations, but the court didn't consider those. And at least when you have this issue where we're making an allegation and we're not a party to the contract and we haven't had discovery yet, in a motion to dismiss, all well-taken allegations are to be considered, all well-pleaded allegations, rather, are to be considered as true.
Okay, but it's also the intent of the parties that ultimately govern, correct?
It is the intent of the parties, and in this case, there are multiple parties in the relationship.
But contractually, it's only BJ's and Fifth Third.
No, there's a web of contracts, Your Honor. And there are contracts between Visa and MasterCard and Fifth Third. There are separate contracts when the issuers agree to enter into the system between the issuers and Visa and MasterCard, but those are not at issue here, as they agree to
Right, I
abide by
understand
the
that, but in terms of your being a third-party beneficiary, I understand that you are a third-party beneficiary, as you contend, to the BJ Wholesale and Fifth Third Bank contract, as well as the Fifth Third and Visa contracts. Is
Right.
that your position?
Right, which has no prohibition on third-party beneficiaries.
Explicit prohibition.
Explicit. Or there's nothing that even implies that there's a prohibition.
Is it, I haven't figured this out, but is it, do you have a claim, let's just say for the minute that the explicit prohibition governs. Would you have could you get relief only becoming a third-party beneficiary to the Fifth Third Visa contract?
Certainly, there's no explicit prohibition in that contract.
But I mean, as a practical matter, does that get you where you need to get?
Because Fifth Third was required to ensure that BJ's complied with the regulations, we believe that would get us where we needed to get, because they breached that obligation, and that's one of the things that we have alleged.
On your tort claim, your point on the reliance, well, I know your point. It's just that you can't be, the fact that you knew that sometimes this happened doesn't defeat your ability to rely.
That's exactly right. As an analogy, and I believe we cited this in our briefs, we know that there are people who write bad checks. That doesn't mean that as a business owner, I can't accept checks anymore, because I know that there are some people who write bad checks. And there's a system out there to prosecute those people. But just because that system is out there doesn't mean that I can't sue that individual as well. There may be two different types of punishments, and that's exactly what we're talking about here, even from the tort context, Your Honor. There may be a system where Visa and MasterCard impose fines, but that doesn't mean that we can't go after them for the damages we suffered, because we haven't been compensated for those damages.
But you're stretching NICAL, which generally focuses on actual representations, here to be some implicit representation that by agreeing to enter into these contracts, we implicitly represent that we will not store this data. Isn't that what you're essentially asking us to find?
No, because the contract incorporates the regulation. So in their contract, they're agreeing not to store. There's nothing explicit.
Okay, so then every since it incorporates the regulation, every proviso of the regulations then becomes an implicit representation of the contract.
Becomes an explicit representation of the contract if it's incorporated, Your Honor, and it's one that we're entitled to rely on. And it's the only way the system could really work, since we can't contract with them directly.
And does that not, for all practical purposes, mean that your interpretation of negligent misrepresentation becomes, under a different dress, a third-party beneficiary?
I don't believe so. I think there's a separate claim there. If you look at, for example, the Danka versus Staunton Savings Bank claim, in that case, a bank had indicated that it would not proceed with a loan unless there was not a problem with a plat. Turns out that there was a problem with a plat, and the individual sued the bank for that issue. Again, it was something they were entitled to rely on, thinking the bank would take that step. And in our case, this is specifically designed to protect us and to protect against fraud. We're entitled to rely on that. That's one of the reasons we got into the system. That's the way the system is supposed to work.
Now, I take it your clients did get some money under the procedure, under the MasterCard and Visa regulations.
Very, very little. Very few of our clients did. And there were also expenses that are not reimbursed under that system. For example, block and reissue charges. Many of our clients had to block their credit cards and reissue new ones, even if they hadn't had fraudulent charges on those cards, because of the possibility that fraudulent charges could be made.
What percentage of the actual fraud losses did you recover?
Very, very little.
10%?
Less than 10%.
Why didn't the regulatory process that was designed to protect your clients, why didn't it provide more coverage?
Visa and MasterCard indicated that the system was just unwieldy. They changed it after this fraud, that it just wasn't designed to deal with anything this big. Again, Visa and MasterCard's testimony was that only 28 to 30% of compliance cases were actually granted when people filed, and very few issuers filed and were able to file. One of the problems was some of the deadlines they had in place. You didn't know you had fraud until a deadline had passed. You didn't know exactly how to file these claims. And because there's no explicit prohibition against going after the merchant banks and the acquiring banks directly, that's another form of relief, and the only effective form of relief that the issuers can get because of the way the system was designed at that time.
Thank you, Mr. Panagopoulos.
Thank you.
Good morning. Is it Mr. Weigel?
Yes, Your Honor.
Good morning, Mr. Weigel.
May it please the Court, Brett Weigel. I'm joined by my co-counsel, Tim Blank. On behalf of Fifth Third Bank, I'd like to take the first 10 minutes of argument and address the third-party beneficiary and the misrepresentation claims, and then BJ's is going to address separately the negligence claim. Let's start with the remedy here. These are sophisticated commercial entities involved in very complex transactions. We're talking banks and insurance companies. These are the visa regulations. They are intended to address everything in the visa world, every contingency, to allocate the risks, and they had a remedy. And the problem, they say, is it didn't give them what they wanted. It was too cumbersome. Well, it's not as cumbersome as 4 years of litigation. And what they don't like is that visa requires you to prove causation. You have to prove that your fraud losses are a result of the BJ's breach.
Could they have recovered 100% of their fraud losses in the regulatory process?
Absolutely. Absolutely. We paid out $3 million in fraud losses as a result of the BJ's compromise. So
what are the claimed losses sustained?
I'm sorry?
What are the claimed losses that have been?
He's correct that the numbers are in the range of 30%, but the reason for that is because there is fraud coming from all sorts of different sources, and you have to tie it to the BJ's compromise. And so issuers will put in claims.
You have to tie it to BJ's what?
To the BJ's compromise, the BJ's breach. And that's why you have a 30% rate. Many of the issuing banks choose not to even file compliance claims because they do have to prove their claims. And there is a lot of fraud in the system.
Wouldn't they also need to prove just the same thing if they bring a tort suit?
Exactly, which is why they don't bring tort suits. That's why
Third-party beneficiary suit?
That's why the issuers, by and large, rely upon the regulations. And this is a system that Visa's created. They update it, they implement it, they enforce the regulations, they interpret them. And this is for the benefit of the system. And, we begin with the premise that this is governed by 302 of the restatement. They have to establish the intent of the promisee here, Visa and MasterCard, to give them third-party beneficiary rights. And what happens is, the Anderson case says that's got to be clear and definite intent. That's a mighty standard, and they haven't come close to meeting it.
This is a motion to dismiss. I understand in the BJ's contract with your client, there is an explicit expression of intent. But what about the other contract?
And I'm glad you asked that question. First of all, there's nothing on the face of this contract, the Visa contract, the MasterCard contract, that would suggest there are third-party beneficiary rights. But Judge Quinlan did decide this on a motion to dismiss. And the irony here is they want to challenge her decision by saying, taking sound bites, the LaPaglia memo, or a statement by a Visa representative, and all those sound bites provide you, if you read them, is to say simply this: these regulations are designed to benefit the system. The follow-up question is, well, doesn't the system include issuers? Yes, it does. Well, that tells us nothing more that issuers are incidental beneficiaries, and incidental beneficiaries do not have third-party beneficiary rights. And so they miss the point because they don't go back and examine the complaint.
Well, how would the LaPaglia deposition come in on a motion to dismiss anyway? It wouldn't be relevant. I mean, you can't look at it.
It didn't come in. It came in at the time of summary judgment, because at the time of summary judgment, when they argued the negligent misrepresentation claim, they came back to the third-party beneficiary claim. It was their second bite at the apple, and they came back time and time again with the sound bites and LaPaglia. And the truth of the matter is, on this question, the question before Judge Quinlan, the question before this court is, did they state a claim for breach of contract as a third-party beneficiary? Judge Quinlan examined both counts, the count that dealt with the merchant agreement, and she examined the count that dealt with the Visa and MasterCard agreement. And she found under both counts they had failed to present any facts.
But I mean, if it's a motion to dismiss, they're not required to present facts. They're required to allege.
But they are required under the Scher case, Scher versus Brandeis, to go beyond conclusory allegations. And here's what they did in their complaint. This is key. In their complaint, they summarized the operating regulations, because they have them. And they summarized them accurately. And then they had a conclusory allegation that says, we're third-party beneficiaries. And what Judge Quinlan says, and what TJX said in the First Circuit, you've got to show more than that. And specifically, the second element of Section 302 is that the promisee has to intend to give you the benefit. And what happens in this complaint is they miss that entirely. Nowhere in the amended complaint do they ever allege that Visa and MasterCard intended to give them the benefit of this promise. What they do allege...
Visa and MasterCard?
Yes. It's got to be Visa and MasterCard, because they're the promisee. It has to be the promisee that intends to give you the benefit. And what they did in their complaint, when they're talking about the Visa and MasterCard contract, at paragraph 242, they said, well, Fifth Third intended to benefit us. Well, it doesn't get you there. It has to be the promisee. And that is fatally defective in this complaint. And I submit to you that you need to look at this claim as to whether or not they stated a claim. And quite simply, they did not. And that's exactly what Judge Quinlan found. And that's why the Third Circuit's decision in Sovereign really has no bearing here. The Third Circuit's decision in Sovereign was a summary judgment case. That's a different complaint. What we have to look at in this
What's alleged in the Third Circuit complaint?
Third Circuit was the same theories. Third-party beneficiary.
What was alleged, though? It's obviously got beyond a motion to dismiss if it was decided on summary judgment.
I don't have the complaint in front of me, but certainly I have to believe they got beyond the basic elements.
Is
And
there any
here-
record that suggests that they filed a motion to dismiss?
I'm sorry?
Did they file a motion to dismiss?
We filed a motion to
No,
dismiss.
In Sovereign?
Yes, and here was the basis, and this is another important point. We filed a motion to dismiss in Sovereign, and what we did, which they didn't do in either case, is put in front of the trial court the complaint or the operating regulations. We did that because we were entitled to put the contract before the court. And we did that in this case in the trial court as well. We gave the court the contract, and we gave the court specified operating regulations. And those are they're in the supplemental appendix in this case. And what those operating regulations say is that Visa reserves unto itself to decide whether there's been a violation of the operating regulations.
Mr. Panagopoulos said that the regulations were not before the trial.
Mr. Panagopoulos, with all due respect, is wrong. It's a supplemental appendix, Your Honor. And they were put in by us in response to notice of additional authority of the Sovereign case. So they're in the record, and it's just like TJX. What TJX said in the First Circuit during the pendency of this appeal, they upheld Judge Young's motion to dismiss, and what TJX said was they focused, one, that the Visa does now have a express disclaimer, but getting beyond that, what they focused on was that as Justice Gant said, that MasterCard had reserved unto itself the right to enforce its own regulations. That's exactly what we put in front of the court down below as to Visa, that the Visa regulations reserve to Visa the right to determine whether there's been a violation. That is totally inconsistent.
Judge Quinlan, though, decided, I mean, it seemed to me, and maybe I'm just misremembering, I thought that the basis of her decision was the language in the contract that they didn't intend to benefit.
I think she goes further, and I'll quote from page 5 of her opinion. After she indicates that she's looked at counts 1 and 2, count 1 being the Visa MasterCard contract, count 2 being the merchant contract, which does have the disclaimer. But she says she looks at both. And she concludes by saying, in its complaint, the plaintiffs provided no facts that would allow a reasonable inference of an intent to create third-party beneficiary status. And I submit to you that more than adequately covers an opinion on the Visa and MasterCard regulations. But this case really is no different than TJX. TJX is a motion to dismiss case. It was examining the sufficiency of the complaint. And the complaint here fails for a number of reasons, not the least of which is that they don't allege an intent to benefit by Visa MasterCard, and secondly, that the regulations are entirely inconsistent with any intent to create third-party beneficiary status.
I could not understand what you were saying with respect to the Third Circuit case. Are you saying it simply is of no importance to us?
It's an entirely different analysis. The question in the Third Circuit on a full record after discovery was whether or not there was a question of fact as to whether Visa or MasterCard intended to create third-party beneficiaries. The question in this case, and the question for Judge Quinlan, is whether or not they stated the claim for breach of contract.
Now I understand.
And they missed the most basic elements. And I think Judge Quinlan's opinion states that. You know, finally, I think as the third-party beneficiaries, the circumstances simply don't, and that's one of the things courts are to look at, the circumstances. The circumstances here don't support an intent to create third-party beneficiary rights. Visa has no incentive to delegate enforcement of these regulations to 20,000 issuing banks. The result is chaos. The result is inefficiency. The result is inconsistency. The result is thousands of lawsuits just like this one that could be filed every time that there's a breach of the operating regulations. This is a system that supports trillions of dollars of transactions every year.
Mr. Panagopoulos says that the Visa people say that they know that their system doesn't protect. At least I think that's what he said.
I think what they said, Your Honor, is that it was a cumbersome process. MasterCard, by the way, never changed its process. Visa made a minor change in their process to allow the recovery of these block and issue costs that he's talked about. But let's remember, we had numerous issuing banks file claims and recover claims against us in this case. And so if it was good enough for them, With all due respect, it should have been good enough for these plaintiffs. They voluntarily participate in a system with known risks. There is risk in the credit card issuing business. And you agree to live by these rules. And they want to simply say, well, we're going to set aside our contract. And they have their own contract with Visa and MasterCard. We're going to set aside ours. We like the other contract better. And we're going to usurp the authority of Visa and MasterCard to enforce their own regulations. Now, I could address, I am out of time, Your Honor. I'm happy to address the misrepresentation claim. I could rest
I
on my
think you'll
brief.
have to rely on your brief, Mr. Weisel.
Okay.
Thank you.
Thank you.
Mr. Prendergast?
Madam Chief Justice and Associate Justices, good morning. May it please the Court, my name is James Prendergast, and with my colleague Gordon Pearson, I represent the defendant appellee, BJ's Wholesale Club. If I might, I would like to address briefly the application of the economic loss doctrine to the plaintiff's negligence claim. To cabin in what would otherwise be potential open-ended negligence liability that would circumvent bargained-for contractual decisions about the allocation of risk, Massachusetts follows the long-standing majority rule that purely economic losses are not recoverable in tort in the absence of personal injury or physical property damage. In part, the rule reflects a policy choice that a party in a commercial setting is in a better position to evaluate its own unique situation and to assess the potential for and possible extent of the economic losses it may suffer. Armed with this self-assessment, the party can then decide whether it wants to protect itself from such harm by paying a contractual premium, for example, or to accept the risk of such harm,
Or to get
or
insurance.
to guard itself against such harm by other commercial means, like getting insurance, as the plaintiffs did here with Cumis.
But the issuers here didn't have much of an opportunity to negotiate with BJ's or any other merchant. I mean, they'd be negotiating with millions of merchants.
But they had the opportunity to negotiate with Visa and MasterCard. They had the option of not to participate. They had the option of securing insurance. They had other possibilities here for protecting themselves against a risk. What this ultimately amounts to, this case, whether it's the application of the economic loss doctrine or otherwise, is that the issuers went into this recognizing there may be a very small risk. Unfortunately,
Right, but
that
it's-
small
it's-
risk, this is the one situation where that small risk
But it came to pass because
Came- come to
of
pass.
what appears to be, at least on the record,
Your negligence.
the negligence of BJ's in not destroying the data, which ultimately was the source of the fraud claims. I mean, you were negligent, and the question, I guess, is why should the issuers suffer when they have no contractual relationship with you and were the foreseeable victims of your negligence?
If I might, the way that they would protect themselves is through contract. Through tort, for the economic losses which they specifically seek to recover here, they have no right through tort to recover those economic losses.
But in that instance, leaving aside Visa and MasterCard, they have to have a contract with you.
Or they have to insist upon third-party beneficiary rights being placed into their contract, or that Visa
No.
insists those third-party
Yeah,
beneficiary
but
rights
Visa and
have to be there.
MasterCard may not want that for their own reasons. In other words, Visa and MasterCard don't want to have all of their regulations upset, but
True.
they don't want to get stuck with having to be hauled into, let's assume that your client was negligent. I don't know if your client was or wasn't, just assume.
We'll assume that.
Okay, grossly negligent. Visa and MasterCard doesn't want to get called into those fights. The issuers have got, as Justice Gantz suggests, 100, 200, 300, 400, 500, 600, 700 merchants out there, and somebody is grossly negligent, and you're saying they don't have any remedy against you?
What I'm saying is, for the sorts of damages that they suffer, the Massachusetts law does not recognize a right in negligence to recover those sorts of damages. And we're talking about the cost that may be associated with reimbursing their own customers. Those economic losses The issuer is in the best position to understand what the extent of those economic losses
How does
are.
that, I know there's an answer and I'm being dense, but how does that square with NICAL? I mean, if you put,
Well, NICAL doesn't address the economic loss issue. NICAL deals with, I
Doesn't it just
believe, that
skip
deals
over it?
with the misrepresentation issue, the third-party misrepresentation issue. There is an exception for economic, under the economic loss doctrine that allows the recovery, at least in Massachusetts, when the claim is for negligent misrepresentation.
isn't that what they're
We're
saying?
not, no, we're arguing, my point is the application of the economic loss doctrine to straight negligence claims, i.e. that BJ's did more than simply misstate something, that they actually did something wrong. And that's where the application comes into play here. The reasons for why we believe that the negligent misrepresentation claim is ineffective is set out in our briefs. But briefly, that's a different
Okay,
ing, and
all
it
right.
goes into
I'm
the whole
sorry.
restatement.
I
and
don't
so
mean
forth.
to get you off.
But beyond these issues, probably the principal issue here is that nothing that BJ's did caused any particular property damage here. There is no property damage. The data remained usable. The credit cards remained usable. All of those damages that the plaintiffs property damage that the plaintiffs tried to heap on BJ's are in fact property damage that they chose to cause as a way of potentially mitigating what were economic losses that would otherwise be unrecoverable.
They had compromised cards. They had cards now which had been compromised and were therefore of no use to the cardholder or to the issuer.
Correct.
So isn't that something concrete?
It's not concrete. It's not concrete in the sense that the cost that they incurred to reissue those cards as a matter of mitigation, to avoid the possibility that they might have to pay their own consumers fraud losses, they fall into the category of economic losses. There is no property. There is no property here that is physically destroyed. And that is the only type of damage that you can recover for under negligence, that or personal injury. And that's what's missing here.
Because you're saying basically all they would get is the cost of destroying the cards.
Cost of destroying, if in fact the cards were destroyed. But
Replacing the
there's a
cards.
whole other issue here. The cards aren't destroyed by any act on our part. The cards are destroyed on their part. The cards are still usable. In fact, after the breach, people used their cards for a long time until the announcement of the breach. They're actually functionally still usable. So is the data functionally still usable. That was the position of the First Circuit as well as the Third Circuit when it addressed this issue. There's
Thank
nothing
you,
else.
Mr. Prendergast. Take a short